Hello, my name is Robert Goodwin, and this is Law on the Line. Hello, I'd like to introduce my guest, Craig Rothenberg, and Craig is an attorney in New Brunswick, New Jersey, and Craig has been practicing for about 20 years, you've told me, and primarily handles general litigation, real estate, and real estate closings, landlord-tenant, and general civil litigation. Anyway, welcome to the show.
Thanks very much for having me, Bob.
And yeah, my pleasure. And you know what intrigued me about inviting you as a guest was your recent foray into television, and it intrigued me. So tell the audience, because it relates to both attorneys and the lay public,
Sure.
about what you just did.
Sure. Well, first, before I get into that, I also just want to say what intrigued me about being on your show is that I opened up my practice about 15 years ago. And when I first opened up my practice, my entire background was all insurance defense litigation. So I started off thinking I was going to take these injury cases, and I very quickly learned that I was going to have to do some other practice areas in order for me to build a practice. So I started taking some criminal cases, and the first case I took was a New Brunswick case, and you were the first prosecutor that I ever had to deal with. And from the beginning, the first time I met you, you were always very, very kind, professional, and polite to me. So when you tapped on me to be on the show, I said there's absolutely no way I could say no to you. So
I thank you for that.
And I appreciated that from the beginning. It always made me feel more at ease when I walked into a prosecutor's office.
Oh, good.
I never forgot that. So
thank you. So let's get back to your foray into television.
My foray into television. Now, I assume you have a website, right? Do you have a website for your law firm?
I do.
Okay. So I have a website for my firm, and I get a lot of weird emails from my firm. Sometimes they're real clients. Sometimes they don't look so real. Sometimes they're phishing scams. I don't know what they are. But last spring, I got this email from what appeared to be a production company in California, and they were telling me that the information said something like they were filming a pilot about families that had adult children that they wanted to remove from their houses, and they were looking to consult with a New Jersey attorney on landlord-tenant issues. My first instinct was I looked at this, I'm like, this can't be real.
Okay.
Like this doesn't look real. So and then I started reading it. I'm like, but I don't see much of a scam here. I'm like, they're not asking for anything. They're just asking for a phone call. And I have a friend in California who actually works in the reality TV business. And I called him up and I said, I'm like, does this look real? He goes, that's a real production company. He goes, they looked them up on IMDb. They have real stuff. So I look them up and lo and behold, they're real. So I have a call with a producer, and we just start talking about some of what they're looking for. Mm-hmm. And essentially what they had told me is that they had two families that they were focusing on for this pilot. One was a family out in the Midwest that they had kind of like a life coach for, and they didn't want that for the family that they were going to film in Jersey. That one, they wanted a landlord-tenant attorney, and they wanted to understand what are parents allowed to do if they've got a kid, an adult kid, who they want them out of their house.
All right, so now you have your prototypical adult kid. He's 35 years old. He is still in the home. He has the bedroom he had when he was in grade school and high school, and he's a slob, hoarder, and just plain old lazy and indolent, and they can't seem to get him motivated to get up and get out. So what do you do, and how does our general public deal with that? Because I have had calls over the last couple of years where adult parents, my age, grandparents or younger, and have that situation. So what do they do, Greg?
Well, this was my phone call with the producer. My first thing was actually just explaining the law and just telling them exactly that. And the first thing that you're going to have to determine is whether or not the person who's living in the house is an occupant or a tenant, right? And if they're a tenant, they're entitled to certain rights that the occupants wouldn't. The tenant's rights are protected by something in New Jersey called the Anti-Eviction Act. And the Anti-Eviction Act makes it more difficult for a landlord to remove a tenant. It has to be for cause, and there are certain definitions of cause that are set forth in the statute. So how do we determine if one is a tenant or not? And the main way is payment of rent. Is
So
this
my 35-year-old occasionally will throw me a bone when I'm, for food or for whatever. When I bug him to death, and by the
Sure.
way, this is just hypothetical.
Yep.
I do not have any child like that. But what do you do? Is that considered, is he an occupant? Is he a tenant? I have nothing in writing, of course.
Right. Well, in that particular situation, one of the problems is if you treat it like an ejectment case and you go to court and on the day of the hearing, the kid gets up and says, no, I pay to live here. I pay money. The judge can very quickly just throw it out and say this case belongs in tenancy court, refile. So if I have a case that's in that gray area where I'm not sure where it's going to go, I start the process of filing for both. And fortunately, the scenario that we're talking about, the parent with the kid that lives at home, you do have a basis to evict under both, evict and eject, right? So you could eject as an occupant, saying they live in my home, this is my home, I don't want them anymore, I've given them notice that they have to leave, and they're not leaving, now I want them out. But at the same time, if you are living in a house, if you are personally occupying a residence of less than I think it's less than two units or less.
Owner-occupied.
Owner-occupied unit, you are allowed to terminate a tenancy at that point on 2 months' notice. So what I would probably do is I would serve a notice to quit saying, we don't think you're a tenant, but if you are a tenant, we are letting you know that you are now, your tenancy is terminated and you must leave in 2 months. I would at the same time file my ejectment case.
And how do you go about filing an ejectment case? I mean, I know it's distinct from landlord-tenant.
It's different. It's still in the special civil part of the Superior Court.
Okay.
But one is filed in the landlord-tenant part.
The tenancy case.
Right, the tenancy case. And the ejectment is in just the regular. It gets a DC docket number. It is a regular special civil case. So you would file that. You would serve your notice to quit, file your ejectment. Probably during that 2 month period, you'll already go to court on the ejectment. You'll find out whether it works or not. And then at that point, if it doesn't work, then you're going to file for eviction afterwards.
So is the notice to quit a prerequisite to the ejectment action? Is there any prerequisite other than perhaps telling your child typically, that take a hike, we want you out?
There's no, the notices are not defined the way they are in the Anti-Eviction Act. But there is part of the ejectment statute is that you've put the tenant on notice that they're no longer authorized to live there.
Okay, so
but it's not the same formality. You can literally say you have to leave, they don't leave, and you file.
And you appear in court, and what happens with regard to the ejectment action when you're in court? You're before a judge, I'm assuming.
Yep.
Is there any kind of alternate dispute resolution in landlord-tenant court for an ejectment action? We talked about that briefly beforehand, about mediation that seems to be throughout the court system. What happens there, and what is that exactly?
Every single time you go to landlord-tenant court, they're going to make you mediate your case no matter what. And the reason why, it's just based on volume alone. You go to LT court in Middlesex County, you have hundreds on a Wednesday, maybe 100, 200 on a Wednesday, lighter load on some of the other days, but they've got a full docket there. And if you don't mediate and if they don't make efforts to try to settle their case, they're never going to get through the backlog. So,
is there still a backlog from COVID? I know.
No.
Good.
I meant the backlog, meaning like the week of backlog.
Right, and there are plenty of cases every week.
Plenty of cases, right? When you show up for ejectment court, they're usually scheduled at 1:30 in the afternoon versus the 9 a.m. hearing. There's a certain day that the ejectments take place. Usually it's in the afternoon. And when you show up, there's usually 2, 3, or 4 that are in court. So I don't remember, the last one I attended, I don't recall them requiring us to mediate. I don't think they make you do it because there's really so few that are in there. But again, if I'm sitting in the hallway with someone, it's always something you would consider. But the difference with LT court and
Landlord tenant.
Yep, sorry, thanks. The difference in LT versus ejectment is in LT, a lot of the time, the tenants owe a lot of money. That if you're going to negotiate with them and say, listen, I'll give you a little time to leave, I'll give you a little bit extra time, they'll take that. The ejectment, you're there because you're fighting. So it's not the most comfortable situation to approach the occupant and say, okay, so when are you getting out?
So let's assume it is that 35-year-old son, and you really want him out, or daughter, and you're in court. It's an ejectment action, and you're before the judge, and you present your case. And I'm not sure what would be a reasonable defense to an ejectment action. I know you mentioned if they converted somehow or another to becoming a tenant, but what would be a defense, if any, to such an action?
Well, I've seen them, one of the defenses, other than claiming to be a tenant, one of them is that I'm an owner, right? That I'm not on title, but I've somehow either contributed to mortgage payments or I've done something that entitles me to be somewhat of an owner of this house, in which case then you can't eject.
Let's assume that falls flat on its face. It's just not credible. There's no written documents that that demonstrate that kind of interest. What happens? The judge then enters an order. So explain that to our audience.
Yeah. So their LT and ejectment are different, and one of the things that's different about them are the names, right? In LT court, you get a judgment for possession, and you get a warrant of removal. In ejectment case, you're going to get the writ of possession, and that's similar. I think the difference with ejectment, I think for landlord-tenant court, the constable or a court officer is going to be the one that performs the lockout for ejectments. The sheriff's office does it.
Oh, really?
Yeah, I think that's what happened in my last case. I don't remember, and I'm not sure why some of those nuances exist specifically, but I think a different office handles the removals for the ejectments. I mean, the process is similar.
So what do you have to do? What does a landlord have to do at that point, or a parent have to do when they get this order from the judge or a writ of possession? I believe is that what you said.
Yep.
You have this piece of papers. Who prepares the writ, and how do you go about facilitating it? Because we now have e-courts. Explain that to the audience.
My office prepares the writ. The writ ultimately, once it gets signed, it gets
by whom?
By the judge.
Okay.
Once it gets signed by the judge, it gets uploaded onto e-courts, and at that point, we get it and we coordinate with the client this lockout.
Okay, and that would be with a sheriff's officer or an authorized person from the court.
Yes.
Are you able to engage in self-help? I think I know the answer to that, but explain that to the audience again.
Never.
That's
you can never engage in self-help.
And why not?
Well, self-help from the landlord-tenant context is right. From the landlord-tenant context, it's extremely illegal, and there's a variety of ways that you can engage in self-help. I mean, the most obvious one would be locking the tenant out of the premises. But other ways that you could do it is you could do it constructively by tenants not paying their rent. You say, okay, you don't pay your rent. Well, I'm not fixing the place anymore, which, landlords hate to hear it. But if your tenant's not paying, you still got to make sure the water's running. It doesn't exactly work like that. So you can't just give up on the place because they're not paying. So from the landlord context, self-help is something, if you bring that to court, you're in
deep trouble.
You're in some serious hot water there.
Okay, so now we have the ejectment action proceeding, and you have an officer of the court that actually changes the locks?
Yes.
Is that how it works?
Yep.
And you, the landlord or the parent or owner of the property, have to be there, I would assume, to give the constable or the officer a lock to change, or you bring the locksmith. I'm assuming that.
You're supposed to hire your own locksmith. The way I've done, the context in which you see the ejectment, listen, the show wanted me to be the lawyer. That example is not the norm, okay? That's a phone call that I get, and what usually happens is the parent's not willing to go through with it, right? Once you explain to them the process, the parent isn't usually willing to go through with it. I don't want to spoil the show that I was on if you haven't seen it, but spoiler, the parent doesn't go through with it.
Okay.
All right? So we come up with other solutions because the parent's doesn't want to lock their kid out. The most common situation that you see for ejectment is when the home has been foreclosed upon and the person doesn't leave. That's when you see it. They're not tenants. They're at that point, they're squatters, right? That's when you see the ejectment usually manifest itself, not so much.
True. That's
Right.
a good point.
It's not the family in crisis. Usually the family in crisis, they got there because the parents have been enabling from the get-go, and they're usually not willing to make the choice.
So when there is a foreclosure and a sale is scheduled and the occupant doesn't leave, it's the similar procedure as you described with the an ejectment.
Same thing. It is the ejectment. It's the most
Right.
common that I've seen that's come
Now,
across my
does
desk.
the lender get involved and hire your firm, or who is that how it works?
Well, it's whoever bought it in foreclosure.
Okay, that's true. Right.
Right?
You're right.
And then, I mean, you'll see some crazy stuff. You know, I've seen ones where they buy it in foreclosure and then the person living there shows up and says, oh, no, I have a 10-year lease. And that's something, if you look at it, the judges are very suspicious about something they call a sham lease, right? Because that's someone who's getting foreclosed on, and they'll enter into this like 10-year lease with their brother to try to make it look like they have a tenant that you now can't remove, and they try to create that as a way to backdoor themselves in. And
The
when
former owner now who's lost the property in foreclosure.
right, but now he's moved back in because he's got a brother who's living there
Right.
with a 10-year lease. So, you know, there are certainly 90% of these cases are run-of-the-mill, but
You got
10% of the time you see the weird ones.
So, all right, let's transfer ourselves over to landlord-tenant. Explain that very briefly. How a landlord, what a landlord has to do to dispossess a tenant, and let's assume it's rental property, non-owner occupied. Because
Yep.
there's a distinction between the
Yep.
two. Go ahead.
Sure. The first thing, though, that I like to get out of the way before we even go into the grounds for eviction and the way we evict is the most common misperception and misconception of landlord-tenant law in the state of New Jersey. And I get this phone call all the time, and if I could record myself and just play a button for all of the people that just call me with this question, they say, listen, I got a lease. Tenant's really difficult. I hate dealing with this tenant. But this thing expires in 30 days. So can I just let the lease expire? And when the lease is up, the tenant's got to go, right? And I got to tell them this 15 times, that when the lease expires in the state of New Jersey, that lease automatically becomes month to month and renews every single month till the end of time, until you have a basis to evict under the Anti-Eviction Act. So the first thing that I have to tell people before they ask me how do I evict, I tell them at first, here's how you cannot evict: an expired lease. So get that out of your head. And I'm telling you, I've said this to the same clients and realtors over and over again, and they call me the next day in disbelief. You're telling me that if I have an expired lease, I can't just make the tenant leave. Yes, the tenant can leave. The tenant can tell you, thank you very much, landlord, I've had enough here, but the landlord's not allowed to say that. And it seems unfair on its face, but it's actually, if you think about it, it is furthering the purpose of preventing homelessness in the state of New Jersey. You would have tenants, landlords, price gouging every single time they didn't think a tenant was paying good enough rent. And that's what the Anti-Eviction Act was designed and created to curb. So once you get that out of the way, now you're into the bases for eviction.
And that's a good cause eviction under the statute, correct?
Good cause, right? And I look at it as being two branches of a tree. On the one hand, you have non-payment of rent. On the other hand, you have holdover. Two things. So first is non-payment of rent, and the only question, it's a pretty quick and straightforward case. Does the tenant have a lease? How much is the rent? Does the lease allow you to collect additional rent, such as late fees and attorney's fees? And has the tenant paid? Do you have a ledger showing the tenant hasn't paid? Okay, tenant hasn't paid $10,000, non-payment of rent case. The tenant's defenses to that case are pretty minimal. The main defense is, I paid my rent. The landlord doesn't know how to keep the records. Here are my records. That doesn't happen very often. The other defense that's also kind of rare is what's called a marini, or a habitability defense.
Right. An old case from, I think, 1970s, early
Yep.
70s, Marini.
I didn't pay my rent because the place is a dump, right? And it can't just be chipping paint and sheetrock. It's got to be real stuff that runs to the core of the habitability of the unit. I didn't pay my rent because I didn't have hot water. I didn't have heat. Well, the gatekeeping to that, because everyone would say that if you just allow that, but the gatekeeping that the court does is, okay, tenant, if you withheld $10,000 because there was no heat, can you show me where you notified the landlord that you were doing that? And two, you should have the $10,000 today
In court.
to put it in the court, and then I'll hold a trial and I'll decide how much you get and how much the landlord gets. And that gatekeeping is what prevents 99% of Marini hearings. They just don't happen that often because the tenant doesn't have the money.
The money, period, end of story.
That's it. So that's your non-payment case. On the other side of the tree, you have your holdover cases. And that's where you have your list of 20 to 25 bases for eviction. The statute is written in a very weird way where there's a different type of notice and a different length of time required for the notice depending on the ground for the eviction.
Cease, and then a notice to quit, if I recall.
But not everything's a notice to cease, right? So some of them are, some of them aren't. And it's written in a way that's hard for novices to understand. But the most common one that you see is subsection D and E, and those are violations of lease, provisions of the lease or rules and regulations. So, for example, let's do the common New Brunswick one, which is violations all over the sidewalk.
Okay.
Right. Right. You're not keeping the property in good condition. There is a term of your lease that says you are required to comply with all municipal ordinances, comply with local laws, etc. I've received violations every month from the city of New Brunswick, which I know you have worked for them in the past.
Yes, I have.
They can be pretty tough with those violations, to say the least, and the landlord has to pay them. So now, what do you do? So the first thing that you do is, in that situation, that requires a notice to cease. And the notice to cease needs to be very particular. A lot of times I get clients who come to me and they're like, I already served the notice to cease, and I look at what they did and I'm like, it's good, but it's not good enough, right? It's got to cite what provision of the lease they're violating, what they did wrong, and what code of, what specific section of the Anti-Eviction Act you're going to rely upon to evict them. So you send them a notice to cease that says, I got 5 violations, it's got to stop, right? Next month rolls around, no more violations, case is over.
You haven't filed anything at this point.
I haven't filed anything, right? You've sent them the notice, stop, knock it off. They've knocked it off, okay? But now let's say you get one a month or two later, another violation. Now you could serve them with a notice to quit. And that says, I've given you the notice to cease. You didn't comply. I got another violation. Tenancy's terminated. End of the next calendar month. After the end of the next calendar month, if they haven't left, now you are evicting them as holdover tenants. They're there improperly. You've lawfully terminated their tenancy. And at that point, the judge is going to hear it and is going to decide whether or not the lease violations were sufficient, whether proper notice was given, and then you might or might not get your judgment.
Under the circumstances, if you have proven that they have violated the conditions of the lease, would they not get the judgment because of possession, the landlord, because the tenant has paid? What would be, why would the landlord under those circumstances not get the judgment?
Well, one of the tricks that can be snuck in is that after the notice to quit, the landlord accepted rent. So that's something that can hurt you. But in my notices to quit, I now include a provision that says landlord's acceptance of any rent hereafter is not deemed a waiver, and we still are filing for eviction, and you're still paying rent, right? Until such a date as a judgment for possession is entered. It's hard to tell exactly where the judge is going to land on it. You just don't know all the time, because sometimes the violations are de minimis, or sometimes there's evidence that you've got a landlord that's tried to get him out 15 different ways, and you get the perception of a vindictive landlord. So it's very difficult to predict in these kind of holdover cases. So when I get clients with holdover grounds, I try to curb their expectations that, unlike a non-payment of rent case, the outcome's not certain. And the one thing that is certain is it's going to take 4 to 6 months between those two notices and the wait time on your trial date after you file the complaint. You're in it 4 to 6 months.
What is the wait time now in Middlesex County, for example? Just to give generally, because it had been long during COVID. Now it's, I know, shortened up.
Yeah, it's pretty good now. It's like, it kind of goes with the calendar year, I think. By the time in the middle of summer, they were back to maybe 5 or 6 weeks, and now there's probably they probably work through a little bit of end of summer backlog, is my guess. You know, people take vacations and stuff like that. So I think the last one I got was 7 or 8 weeks, but it's still, it's moving now.
Calendar is moving. What should a landlord expect in when they appear in court in terms of if they don't have an attorney, and many people don't, the manner in which to present their case? What should they do to prove their cause of action, whatever it may be? How do you?
Yeah.
What do you suggest? What are some tips? Tips how to prove.
That's a
your
great
case?
question. Well, first of all, if you're a corporate entity, you have to have an attorney,
Okay.
right? So they get these cases. I get calls all the time from people whose case just got adjourned or dismissed until they get an attorney. So
Would that include an LLC?
that does include an LLC.
Okay.
Yep.
I want people to realize that.
Right. You got an LLC. People ask me all the time, should I transfer ownership of my property into a corporate entity or an LLC to protect myself? So yeah, you could do that, but just so you know, if you ever have to appear in court, now you need an attorney.
Greg, we got about 45 seconds.
Let's
so
wrap
go
it
ahead,
up and
wrap it
answer
up.
your question. You know, you start me on these questions.
I know.
I could go off. I could do
I
this
know.
for hours.
That's the point.
All right, so let's wrap it up. So if I were a pro se landlord coming to court, have your exhibits organized, have 4 copies of each exhibit. Your main exhibit is your lease. Your next exhibit needs to be your ledger. You need to have, if the tenant is going to challenge the ledger, you need to be able to support it with payments, whether it's electronic receipts or bank receipts or anything like that. You need to show that you are registered as a landlord in the
City,
municipality
right,
in
that's a
which
very
you're
good
in, right? And those are the key components. And if you think you have a tenant who's going to complain about conditions, have your emails and correspondences, even text messages,
Or
ready
maybe
to
photographs that would support your position.
go. Or photos.
But you made a good point, and just one last thing before we wrap up. That landlord registration. I know some landlords don't do it, and then they get caught up. Explain that real quickly.
Yeah, that was something that started around the COVID time, where they started really saying you need to file this landlord registration. And townships had these forms that were like $100 to fill out, and you just fill them out. You say, I'm the landlord of this property. Township gets their $100, and they've now reached the point they're now a prerequisite to filing the complaint. So if the landlords, I get calls all the time. I tell them, go register, and then we'll get your complaint filed.
Because otherwise you won't have standing to bring an action.
It just gets bounced back.
All right, I think I've gotten the cue to terminate the landlord-tenant part of the show. It was a pleasure.
Thanks,
and
Bob.
I learned a lot, and I hope the audience has, and good luck with your budding career.
Thanks, Bob. Really appreciate being on the show, and it's great spending some time
Thank
with
you.
you.
Thank you.